All right, thanks, people. Sorry about that. Every time. No volume. It's on there now. That was Finnegan. I was just saying he's our puppy Pomeranian who really bothers all of our older Pomeranians quite a bit. So he's just down here wanting to play in the room here while I'm doing this. Okay, I'm literally fresh out of a CPP disability hearing. I had about 15 minutes between getting out of it and coming here. Just enough time to grab a little drink here. So today we're going to be talking about CPP disability back pay and what you can do if you think you're missing money, ultimately. Sometimes they get it wrong. Most times CPP disability will have it right, but every now and then they do get it wrong. So we're going to talk a bit about that, things you can do. All right. So let's start with the basics. CPP disability back pay is the lump sum retroactive payment that you're going to get once your CPP disability is approved. It covers the period from when Service Canada decides that your disability began up to the time your monthly payments start. Now, mistakes can happen. Service Canada can pick the wrong date, or they might. Another rare area where they get it wrong is they don't get your children's benefits in there. Okay, hold on. I got to call in the troops here. Just 1 second. I got to get someone to come get Finnegan here. Okay, hopefully that will help. So one of the areas where it can be a problem is if they don't put in the benefits around your children as well. So that can often get left out, or the information doesn't get input quickly enough for them to calculate it. But yeah, that is usually, yeah, we're having a lot of problems with this guy. There we go. He's out of here. So how it's supposed to work is they will set a start date for your disability. That's based on when the date they believe the disability happened. The other part that plays into this is they will look at going back 12 months maximum from the date of your application. So often that means you will get the full 12 months unless your start date of disability happened within that 12 months, and then you'll get shorter than the 12 months. They'll only go back to the start date. In fact, it's not just the start date, it's the start date plus 4 months. So again, so the start date, whatever the getting the proper start date chosen, if it doesn't go back far enough, that can eat into your 12 months of back pay. And like I already mentioned, the children under 18 is a big one. Whether they're all on there, you'll know if they're not on there. And that is something that can be corrected. All right. Okay, we covered that. So what do you do if you're missing? You just want to let them know as fast as possible and request the reconsideration of the miscalculation within 90 days. So that whenever you get a decision from Service Canada, so that in the case of an approval, like they've approved your benefits, but you disagree with the amounts, that is still something you can appeal, even though it's not a denial. You can still appeal things like this. So ideally, you want to get the complaint in within 90 days of learning, because you technically are still supposed to follow the 90-day appeal periods. So get that request in, provide them the corrected information, and typically they're going to they will let you know. You may not want to, like the date of disability. It may, well, I guess it is something you can appeal right up to the tribunal if you wanted to. If there's a disagreement over when that date is, often it's not worth fighting over because it might only be a matter of a couple of months. So when I say not worth fighting over, you could fight over it yourself. It's not going to pay you to hire a lawyer or something like that if you're going to have to pay people to help you with the claim. But if you want to just do it yourself and try to prove that it should be a different onset date and that the difference in the onset date will matter, sometimes it won't matter. Like the change in onset date won't cause you to get more months of eligibility because you already have the maximum 12 months that you can get. Is usually what would happen. So if it's going to be situations where trying to push your onset date back a little bit further would allow you to get more of that maximum 12 months from the date of application. Now it's maximum 12 months from the date of application, but you also get every month after the date of application up to the time you get approved. So those are the two parts that you want to think of with the retroactive payment. All right, so that's pretty much it. I won't, I'm kind of repeating myself here a little bit. I didn't have as long to prepare for today, but I certainly can answer any questions people have about retroactive payments. It is something I deal with. I won't say I deal with it every day, but I deal with it quite often. Okay. So what is on people's minds today? Any questions you have about your disability claim, things you want to know, things in the news? I had a good conversation last Friday with I'll show you the website. I'm arranging to get basically a tour of this product. I had a good conversation with one of the physicians affiliated with this product. Let me share my screen here. So I'm going to be arranging to get a tour behind the scenes, and then hopefully I'll be able to bring one of the people involved with this product on for an interview and to review further. Where's my share screen? Right here. So this is an interesting product. There it is. Right here. Come on. There we go. It's called C2 Benefits. What it is, it's an automated way to do your disability tax credit application. So it's automated. So you basically you pay, where's the fees down here? There's a charge for it. Yeah. So you can self-navigate or have a consulting navigated. You basically start the application and the software takes you through all the questions and helps you fill in your answers. Then you would send the form off to your doctor. And the interesting thing that I thought that was quite interesting, why I wanted to talk to them, is they do have a doctor affiliated with this who will, once you don't have your own doctor, that doctor will review your application and sign off on it, which I thought was quite interesting. So you do pay more for that as well, but it's just interesting to note that they do that. Very interesting. Now they do, if you there are additional fees if you have to get like your full family doctor's file and things to go along with what's used here, but yeah. So I thought that was quite interesting. So I'll be learning more about this. Oh, sorry, you're not seeing the. Sorry, you weren't seeing this. I clicked over and you weren't seeing what this is what I was showing you. So this is the doctors that are associated with the Benefits 2 product. So this is where you can actually fill out the form through Benefits 2 and they have a doctor who can review it and sign off on it for you if you can't get your own doctor. It's always ideal to have your own doctor, but I thought that was interesting. I spoke to the doctor who does this side of it and is involved with the other side of it as well. So it's interesting. So I'm always looking for things new. Certainly, this might be a good alternative for people who want to do their application and want to have some guidance and not have to pay someone to do the application for you. We don't do these applications for people, but there are companies out there that do. You can pay them to do the application for you, either pay them flat fees or they take a percentage of what money you get, that kind of thing. All right. Oh, yes, the award. I can announce the award. It's official now. I got selected as one of the best lawyers in Canada. It's an award. The best lawyers. It's kind of funny the name of it, but that is actually the name of it. Let me see if I can find it. Let me see. Best Lawyers Canada. So this is an award you will see many lawyers will promote that they have. Okay, I'll share my screen here. It is an honor to get it. I'm not going to lie. The way you get selected is you're nominated. So I did have someone nominate me, and here, let me share the screen here. Sorry, I was nominated, and then once you're nominated, they will they basically contact lawyers in your area, so in your practice area and geographic area, and they ask them to fill out a survey on whether. And then based on the survey, they decide whether they're going to allow you to be awarded this. So it's based on peer reviews. It is interesting. So there are different ways that these awards work. This one is just based on peer reviews from other lawyers. So the 2026 Best Lawyers. I should be in here. Let's see. Better be. There it is, David Brannon. Right there. That's me. Yep. Best lawyer. So I was recognized in the area of insurance law that's for my long-term disability work. I think I saw the statistics. 6% of lawyers get awarded through best lawyer. So it is a small group. Now that is lawyers who you have to nominate yourself or have someone nominate you to be selected. But it's still it's a good honor to have. I'm happy that I was selected. There was other awards. I'm also listed with, there's another similar award in Canada called Lexpert. They're another legal magazine that selects lawyers. So I have been selected in there too for a couple of years now. That is also, they send out, I know because I get the survey. They send out the survey. I'll probably start getting the best lawyer surveys now too. They'll send they'll send out surveys asking other disability lawyers in Canada, who would you recommend at different parts of the country. So that's how I get on the Lexpert one too. They have so there's one of the criticisms of these awards is sometimes they're just a popularity contest. They have apparently algorithms within their within the applications and the questionnaires that people fill out that only a certain amount of them can come from lawyers who are affiliated with you. So you just can't start everyone in your law firm voting for everybody in your law firm, that kind of thing. So they will filter out, they will only accept a broad kind of range to make sure that they're getting fair results. There you go. So you'll soon see this on my website. I'll have that indicated that I'm a best lawyer, got the best lawyers for 2026. And for both best lawyers, Lexpert, which again is another company in Canada that rates lawyers. And yeah, those are the only two. Thank you. Thank you. I appreciate the congratulations. Robert, what does Robert got to say here? Robert says, I was approved recently. My bank account reflects this fact, but I have yet to receive. Oh, congrats, man. I've yet to receive the letter of explanation from Service Canada. My simple calculation suggests all good. Yeah, that's great. You will get, what is it called? I was looking at one today. They're called it is the letter of explanation, but a payment explanation statement is what it's called. So you'll get that in the mail. It will show, when you get the payment explanation statement, it will show the years and show how many months of payments in each year, and then it will show the amount of the benefit. Each year, the amount of the benefit will go up slightly. So that'll break it all down for you, but it likely is correct. I've only ever seen once, well, more than once. I've seen only once that the calculation was wrong because of the onset date. I've seen several times that they forgot or to put in the children's benefits, or the children's benefits didn't get processed in time. But that's an easy thing to fix. They will just go and redo the children benefits and get it done. It just means it didn't get put through in time. All right. Oh, I was up till 2 a.m, if you can believe it. 2 a.m, writing, trying to finish. I have to do a presentation to a bunch of lawyers in Fredericton, New Brunswick. It's for the Canadian Bar Association. That is the National Association of Lawyers. It's kind of a weird name, but that is the name. The Canadian Bar Association. Bar is a word. That's a word that comes from courtrooms where there's, the little bar. Sometimes you go in a courtroom and you see the bar that separates the gallery from where the lawyers are and the judges. Like there's literally like a bar. That's what it refers to. So when lawyers get called to the bar, it means you're able to go past that and go into the lawyers area. It's kind of an old way of saying it, but anyway, the Canadian Bar Association is putting on a conference in Fredericton later this month on evidence and experts. And I was asked to speak about surveillance and admissibility. Like, when do insurance companies have to disclose surveillance and when can they keep it a secret? So I wrote a paper all weekend, worked on a paper, because you have to, for these conferences, this one in particular, the organizer wants you to write a very detailed paper, like a report kind of thing, with legal citations, the whole works. So they want a very detailed report, and then they want you to speak about it. You only get to speak for 15 minutes, which is kind of funny, but they put more emphasis on a good paper so that the people attending get to go away with very good. Think of it as like you go there and you leave with a bunch of good legal research on different common issues that you're dealing with. So it is quite useful, but the emphasis on a very good paper, and then your presentation is just to give an overview of the paper. So anyway, I'm up till 2 a.m. trying to get that damn thing finished. And oh, my nerves, man. Ugh. It's kind of, you don't want to get it wrong because it's embarrassing if you're up in front of, 50 or 60, 70. I don't know how many lawyers will be there, but everyone's going to be, you know what lawyers are like. They're all scrutinizing, looking for mistakes. Oh boy. But anyway, yeah. So I got that finished. It was interesting. I had given a talk on surveillance. They invited me back because I had given this talk back in 2015 on a slightly different area. They wanted me to talk about it a little bit differently. But the point of it was they wanted to know was what is the rule currently in New Brunswick? And because there have been some big changes in Ontario, and they wanted to know what do these changes in Ontario mean for New Brunswick? Will things change here? Basically, the way surveillance works is normally when you're a lawyer working on a case for a client, there is something called litigation privilege. That means you are allowed to do certain research, create certain documents and such that are allowed to stay confidential because it's part of your work on the case. So think of it as like all my notes, strategies, and all these types of things. I don't have to give that to the other side because I'm allowed to keep things necessary for me to work on the case. That is generally what litigation privilege is. And New Brunswick has very strong litigation privilege rules. It's right in the Insurance Act, actually, that allows for litigation privilege. Now, the other part, that is important to understand is that there's also a conflicting rule of disclosure. So the conflicting rule of disclosure, once you start a lawsuit, you have an obligation to provide every relevant document to the other side that you have in your possession or in your client's possession. So you can see when it comes to surveillance, where an insurance company, and the cases usually involve an insurance company pays for surveillance, and then they don't want to give it to the other side. They want to save it. And basically, what a lot of insurance companies want to do is save it. And then if at trial you give testimony, they can gotcha. They can say, oh, you're saying this. You said you never went on a roof. Your Honor, we would like to enter into exhibit surveillance video, whatever. And this is video showing him on the roof. It shows he's a liar. Like that's essentially what they want to be able to do. And that is what the tension is. Is the insurance company able to keep the surveillance private and confidential and only spring it on you at trial? That is the question. So in New Brunswick, there was a case in New Brunswick. It's called Maine v. Goodine. It is the leading case in New Brunswick. Well, first of all the provinces have treated this differently. New Brunswick, Manitoba, Saskatchewan, and to a certain extent, Alberta and British Columbia all have a similar way. All those provinces require the insurance company, if there's a lawsuit, they have to indicate that they have the documents. Now, in the case of British Columbia and Alberta, they just have to say they have documents that they don't want to tell you what they are. In Manitoba, Saskatchewan, and New Brunswick, they do have to list. They have to tell you that they have surveillance documents. So that is quite important. So in New Brunswick, Saskatchewan, Manitoba, they do have to give you notice that they have surveillance documents and the dates and actually the name of the surveillance company or person, so that is some information you can get. But in these provinces, New Brunswick, Saskatchewan, and Manitoba, they don't have to tell you anything beyond that. Okay. Now, if the insurance company only wants to use those tapes if it's called impeachment. So if they only want to use it, like I explained, when you say something and they say, wait a minute, we have a video where you're doing the opposite, that's called impeaching your credibility. So if they only want to use it for that, then they don't have to do anything else in New Brunswick. If they want to put the surveillance evidence in as just evidence to show to a jury or a judge to show like, oh, look, this is a depiction of what this person can do, then they have to disclose it to you ahead of time. But again, if they only want to use it for impeachment, that is to kind of catch you in a lie. First of all, for that to work, you have to say something that would contradict the surveillance. So the danger for the insurance companies, if you never say anything that contradicts the surveillance, then they can't get it in to get you. Now, if they disclose it to you ahead of time, give you a copy and all that, they can then just enter it as any other evidence into the trial and show it to the judge and that kind of thing. Where things differ is with Ontario. Well, they differ between Ontario and then you've got Nova Scotia and Newfoundland. So let me just cover the whole country here. So we understand that there's a group, what I would call the middle ground provinces, which are New Brunswick, Saskatchewan, Manitoba. They're the middle ground where they require the other side to tell you they have surveillance, but don't have to tell you much beyond that, other than the date that you have it and maybe the name of the person that did it. Closely aligned with that is Alberta and BC, that basically just require you to indicate that you have privileged documents. You don't have to say it's surveillance. Okay. Now, the other end, you have Nova Scotia and to a certain extent Newfoundland, although Newfoundland it's not completely clear how it will go, but I think they've somewhat followed Nova Scotia. Nova Scotia is the Wild West. In Nova Scotia, you either, if you want to rely on the surveillance as evidence at the trial, then you put it in your disclosure to the other side and you give them a copy. If you only want to use it as a trap, you don't have to even let them know you have it. Okay. So it's not even that you indicate that you have a privileged document. You literally don't have to even refer to it anywhere. You can just keep it secret, spring it at trial. And there's been some spectacular incidences of that happening in Nova Scotia with the springing surveillance and surprise witnesses at trial. I've not been directly involved in them, but they were involved in firms that I worked with before. Now, that would be the far end, that you don't have to, you can keep it completely secret. That is Nova Scotia and to a certain extent Newfoundland. The other side, the other end of the spectrum, so that's the one extreme. You've got New Brunswick and Manitoba, Saskatchewan in the middle. Then you've got the other extreme is going to be Ontario. And Ontario has had a few cases happen in the last, I'd say over the last 5 or 6 years, 5 to 7 years. Time kind of flies. Those cases have slowly, in Ontario, has gone more towards a fairness approach, away from the rights of parties like defendants to keep things privileged. They're moving the other way in Ontario. So in Ontario, you are required, like you are in New Brunswick, Manitoba, and Saskatchewan, you're required in Ontario to list in your documents that you give to the other side. Like you have to give the other side an index of all the documents you have. And in there, you have to list their surveillance with some basic particulars around it, like the date, that it is surveillance, that it's a tape, a report, or whatever it is. And now the difference in Ontario is that the other side, so it would be the plaintiff or the injured person or the person with the disability claim, they're allowed to then inquire for more details during an oral discovery. So you get the documents, you can press for more information about the surveillance, like what type of activities are on there. They don't have to put it in writing, but you can question. So you can do a deposition in Ontario to get more information about the surveillance. Now that is the only place that in my understanding, that's allowed to be done, is in Ontario. And the other difference in Ontario as well is that during the trial, they have a very much, the judge handles the surveillance very carefully, in that if it's going to be used, there will be rulings during the trial on whether the surveillance can be used, to what extent. And the judges have these kind of rulings, little mini hearings within the trial to decide what they want to do. Again, Ontario is the only province that I've seen that has that robust of a process for dealing with their surveillance. And the question is whether that is going to move into New Brunswick and other provinces, or will New Brunswick go more towards Nova Scotia, where it's the old Wild West? I think probably not, because they're already less the Wild West than Nova Scotia. I guess the real concern is, well, not concern, but the real thing would be, would it move more towards what happens in Ontario? So that's what I'm going to put to the people that are there and see what people's thoughts are. I try to take kind of a middle of the road approach, not really arguing for one way or the other, because I am talking, the lawyers I'm talking to include both people like me that represent people and also lawyers that represent insurance companies. So I didn't want to go in there just arguing one side of it. I kind of gave both sides, gave advice to both sides on how to handle it and what could be done in New Brunswick to either protect your surveillance or to get more details around it if you're on my side. Surveillance it's just a very touchy thing because it is such a lightning rod. It can be misinterpreted, and for that reason it has to be handled very carefully. That's what Ontario has emphasized, whereas provinces like New Brunswick and to the more so Nova Scotia have really emphasized for the need for people to have the ability to test the credibility and, if necessary, surprise people at a trial with a videotape that contradicts what they're saying in evidence. It is devastating. Like, it's quite devastating if you're giving evidence at a trial and the other side can contradict you through a video. That can be devastating, absolutely devastating. So that's why Ontario in particular they've really limited the extent that can be done because it is so prejudicial to if it's misinterpreted in any little way, like the damage is so bad, that they've put some guardrails on it that we don't have in New Brunswick. So yeah, I think I may have just answered that with all my rambling. So Ontario is the most favorable to our side. Let's put it that way. That in Ontario, you get to know that the other side has surveillance. So it's never going to be that they have it and you don't know about it. And the only question is going to be, then in Ontario, we can find out more about it through the oral discovery process. And then you either going to, by the time trial comes, you're either going to have copies of it or you'll have a pretty good description of what it is. So you'll know what to expect. It really does. Like places like Nova Scotia say, well, why would you ever do that? Like, the whole point of surveillance evidence when you want to use it for impeachment is surprise. Like, it doesn't do any good to tell people ahead of time what it is because they will alter their testimony and things, right? So those are just two sides of the coin, and that's where the country is right now. So that's what I'm talking about. And I was up late trying to finish that paper, trying to get all the citations in it correct, linking. The people have high expectations now. So when you do a paper like this, people are all getting it as a PDF. They want all the cases to be linked to the actual, like all the references to cases. They wanted to be able to click on it and link to the case. So I had to get all those in there. But anyway, poor me. Not mean complaining here, but I did not want to be up till 2 a.m. Took a lot longer than I thought. All right. Hey, Tyler, good to see you here. I'm doing fine. You probably arrived after I got started, but I literally walked out of a tribunal hearing and came right on here. So I didn't have a lot of time to get ready. I still got my uniform on. And so I'm a little burned out too, because those hearings take a lot out of you. That one was about an hour and a half. And we don't know the result. When those tribunal hearings end for CPP Disability, they take a month to get back to you. So it's a tricky case. My client did very well, but it's hard cases. A lot of cases I take on are hard cases. So it's a hard case. And we'll cross our fingers. I think there's a chance we can win, but there's also a chance we don't. So we'll just have to cross our fingers and hope. A lot of these CPP are very much on the border, especially difficult cases like this that deal with without getting into details. This is the type of case where we have to prove that the disability started back in this case, it would have been 2015. So we're dealing with a very hard case when you have to go back 10 years and prove a case based on evidence that was created 10 years ago. It's much harder than trying to prove a case based on evidence right now, because it's easy to get evidence right now. You can ask the doctor to give an update and give opinions. Very hard to do that when you're focused on what was going on 10 years ago, because any statements now are not as effective than statements that were made at the time. So you're really stuck with what was happening at the time. And that's what makes these cases very hard. All right. Let's see what else we got going here. So the news, for those of you who may have just showed up, I said last week I got an award. I've been named as one of the best lawyers in Canada for 2026 for insurance law in New Brunswick. It's my home jurisdiction. It's an honor to get this. And there's, I think, 6% of lawyers in Canada get this award. You have to be, it's voted on by other lawyers who are in your practice area, in your province. They have to agree that you are one of the best lawyers. Otherwise, you don't get the award. So not everybody can get it. Okay. Let's see what else we got going on here. Let's go check out the forum and see what the deal is over there. Let's see what the deal is over there. You guys can help me answer some questions. Oh, Sherry, it's good to see you here. Sherry, I want to thank you for leaving. Sherry left a wonderful review on our Halifax website, or our Halifax Google reviews. Was extremely well done. Honestly, Sherry, I really appreciate it. Very helpful. I was speaking last week saying like the Google reviews are a constant battle for us because honestly, like Google wants to see you constantly getting reviews. They want to see you getting reviews, not too many, but they want to see steady reviews over time. And so our Halifax office is always an office where for whatever reason, we just don't get as many reviews there. So I always ask people, if you're going to leave me a review, leave it there. How does the nomination process work? Anyone can be nominated. So for the best lawyers, anyone can nominate you. And in my case, I was nominated by, I don't know if you guys remember Maddie. She used to work with us before she went back to school. Maddie put my name in for it. I didn't even realize it. Maddie put my name in and I got a notice. Then Maddie was gone. Then out of nowhere, I got a notice that my name has been submitted. It's gone. The questionnaires have gone out and they'll let me know how it goes. I was like, oh, great. Okay. And then, the questionnaires get sent out. I haven't seen them because I think they send the question out to lawyers who are already in the best lawyers in your region, and they will pick lawyers who are in your practice area. So whether they're in best lawyers or not, they will pick lawyers in your region who are in your practice area and can attest on whether you're someone they would recommend or not. Okay, or that you're recognized as one of the best in the area, both the area geographically and the area of law. Yes, Maddie was a lovely person. I haven't heard how she's making out. She went back to school to do counseling. So we were very sad to see Maddie go. She was fantastic. So here is, just in case you're interested, this is the Best Lawyer website, and they go through their methodologies. Oops, it's not showing. So this is the methodology, peer review through and through. So this is their methodology. They've been doing it for 40 years. So you're nominated by anyone but themselves. So Maddie did put my name in. We saw honestly, what we saw is we saw some other lawyers get named to the best lawyers. And she's like, what is going on? I think you're a better lawyer than them. I'm putting your name in. I was like, okay, go for it. So she put my name in. Then it goes through peer review. So currently recognized lawyers provide feedback on the caliber of the candidate's work. Yeah. Analysis of the feedback. Results are collected. Feedback from voters is reviewed. They then confirm that you are in good standing with your local bar association so that you're licensed, that you don't have any, you've not been disbarred or lost your license or anything like that. And then they release the results. Yep. So that's their methodology. Okay. We got a question here. Let me get rid of this. So Robert's saying, FYI, 19 weeks beginning to the end of my CPP. Okay, right around 19 weeks. That seems fast. So you got approved right on your first application then. 19 weeks. How many months is that? I should know the answer to that. And I'm typing into Google. Okay, 4 months. Wow, that's fast. How did you get approved that fast? That almost seems impossible, sir. 19 weeks beginning to end for my CPP approval first time around. That is as early as I've ever heard it. That's like 4.37 weeks. That's fast. Very fast. What's your secret, Robert? I'd like to know, actually. What is your secret? Let me know, because I cannot. That is very unusual to be approved that fast. Very unusual. What? You and Sherry was approved in under 4 months. Okay, you guys know something I don't. What is going on? Obviously, you deserve the benefits, because if you're getting approved that fast, or you put together, you did a very well. Maybe you just followed the. I know, Sherry, you said you've used my booklets and things, so maybe that's what it is. You just have to. You left no stone unturned, and you put in a very thorough application. That'll do it. That will do it. That is actually the secret. So both Sherry and Robert were under 4 months to be approved. Wow. Oh, wow. Another one, 5.5 months. Okay. All right. You guys have figured it out. That is good. So for that to be the case, you must have strong evidence. And to be approved in that kind of time, you would need to have strong evidence of the disability. You'd have to have strong evidence that you've done all treatment and that you're not expected to improve. And you would also have to show that strong evidence to show that you have made reasonable efforts to stay in the workforce and that it's not likely that you're going to be able to. Interesting. Very good. Very good. So you did it. You mailed it in. Yeah. Yeah, we still mail them in. We don't do a lot of applications for people. I prefer not to do them. I try to really get people to do them themselves, but we have to mail them in. I still would recommend online if you can. I think it is faster to do it online. Oh, many use my books too. Right on. Okay. Maybe what I got to do is the next version of the book, I'll get either you or Sherry to write the a forward in it saying, I use this book and I got approved in 4 months, 5 months. That's awesome. Yeah, I got to update the books. Things are all changing, right? Like things have changed with AI coming in. Like things are all up. Everything's up in upheaval. I'm sure more people are going to use AI to help put together their applications and things like that. And that's good and bad. Like anything, it's good and bad. Certainly, like what I use AI quite a bit in my work. And I can tell you that you absolutely, at this point, I'm sure it's going to improve, but you cannot rely on ChatGPT for legal citations. Not even close. Not even close. It's very wrong. It gets it very wrong. Like, for example, I was using ChatGPT just to help with writing my paper, brainstorming. Like, it's very good for these types of things, for brainstorming, for wordsmithing things. What it is not good for is interpreting cases or suggesting cases. Very bad. Very, very bad. And most lawyers know this, because there have been lawyers that have been embarrassed because they will do a brief and ChatGPT will cite the cases, and they're real cases. The problem is that, like, it's not so much that it will invent a case. Sometimes it will invent cases that don't exist. I've seen that happen. But it's more that it will misinterpret the case on purpose. So that is the problem. It will misinterpret the case. I've seen it happen with CPP disability cases. I've seen it happen with all types of cases. It will just misinterpret them. It will give you quotes from the case that don't exist. And then you ask it, why did you do that? It's like, oh yeah, you're right. I shouldn't have done that. It's not designed. It's designed to predict answers and things the way that these large language models work, and they generate these types of errors. So Like, so lawyers will say, well, why do you even use it if it's going to like, well, it's like I was telling my wife, I try to use the analogy. It's like a car. If you say, oh, I get in why would you drive a car? Because if you get in and push the gas all the way to the floor, you immediately will crash. It's like, yes, if you use ChatGPT and say, write me a brief with all the legal citations, you are going to crash. But it is quite good for certain problem solving aspects around, and it can help with wordsmithing, like word with writing and wording around a brief, but it is quite poor at legal citations and quoting the law. Very poor. It's good at the law in general, writ large. Like, so ChatGPT is very good with large legal concepts, but it is not good about very fine legal arguments that rely on certain cases that stand for a proposition. So this is where lawyers will get into a lot of trouble by citing the wrong case. You're not allowed to misrepresent to the court what a case represents in terms of the principles from the case. So that is where you as a lawyer cannot. The problem I'm concerned about is people using ChatGPT to write, say, a CPP hearing brief. I'm quite certain that people are now submitting them with ChatGPT and they'll be complete garbage, right? The things being cited in there will not be correct because it looks extremely, when you see it, it looks like it would be real. And it's talking about the case. Okay, yeah, that is a case. That's a well-known case. But if you then go and read that case and try to find, like, where is it coming up with this? Where did this case say this? Like, I don't see any, like, it doesn't. It will take well-known cases and then say they stand for a certain proposition that they don't. So we're struggling with it in the legal profession, but this happens. This is no different than when I've seen several of these things happen over time. Like, even in my legal career, when I was starting my legal career, it was just when everything was transitioning from those books, like you see in the background there, those red books. That used to be where all the legal law was. You had to get these books. These books were published. All the cases, reported cases out of courts were in those books. Now, of course, that doesn't happen anymore. They're all on databases like Canly. So when I started, there was no Canly when I started law, but they were just starting to make these databases. There were paid databases when I was starting in law, same ones that are still around, actually. So those paid databases would go to all the courts and collect all the judicial decisions and put them online so you could search them, which is way better than searching them through these books, right? And then Canly came along as a way to make it publicly available, right? Because up until Canly, the only way to get access to most cases was through paid legal products, like paid search engines. Basically, I have a paid one, so I don't use Canly anymore. I use one called Westlaw, which is a high-powered lawyer, like it's a high-powered legal research thing for lawyers, basically. All right. Well, that's great. I'm glad you guys you got approved so quickly. You're proving my point. I got interviewed for another award. Actually, I don't know what's with all these awards, but I got interviewed by Canada HR Magazine, which is, it's more to do with the employment law work that I do. And they were wanting to know, like, what's going on? What are you all about? And my thing is all about, like, empowering people through education. That's always been the approach we've used here. And it has worked. I've built my whole practice and career around giving people education, and then a small percentage of those people will eventually still have to hire you. That's basically the whole point. The whole marketing pitch is give away free stuff. And yes, several of those people will be able to use your free stuff to get what they want. They won't have to hire you, but there's always going to be a percentage of those people that still have to hire you. And because you've given them free stuff, they're more likely to trust you and to hire you. So that is my marketing approach. I'm not the only person that's worked that way. I learned the approach from lawyers in the US, basically, who learned it from other people. But That's why, like, when I started my practice, there was another lawyer who I knew locally who was encouraging me and said, "Why don't you join, like, there's some mentors in the US. Their whole thing is you need to write a book and then give it away for free to clients," right? You're like, "What? Why would I do that?" But that is my whole approach. I built my whole practice over writing a book, giving it away for free, and having people hire me based on the book. That's where I get most of my clients from. People who've read my books. And that being said, I have the newest book supposed to be coming out by January. If I'm able to get it done in time, it'll be the book I'm writing on wrongful dismissal, the employment book. Yeah, I agree. I think it's a great way to get clients. Books, they're good for so many reasons. Now, maybe books are more irrelevant nowadays that people with everything's online. So maybe I'm a fossil and books is not the way of the future, but books, people don't throw out books. If you get a book to somebody, they'll remember who you are because they'll be like, "Who is that lawyer? Oh, go grab that book." Book people don't usually throw out a book. If a book is done well, it does give you more credibility. If it's a terrible book, then it can hurt your credibility. Um, but the books, yeah, the books have been great for me. I've encouraged other lawyers to do books. Most lawyers won't do books. They just don't think it's worth it. And there are a few that think, why would I give away stuff for free? But that's the whole point. Like, you give away stuff for free in order to show people that you know what you're talking about. And also, when you give things away for free, people will trust you more, right? Especially if the book is well done. All right. So let's go. I was going to go look at the disability claim forum. Let's go check that out for a minute, answer a question, and then we'll call it a day. So LTD and retraining. Oh, wow. This is probably too long. Oh, that's an answer. Okay, sorry. So this was a question about retraining. It says here, we can't financially afford to lose the LTD benefits for a year while I retrain. Is it possible? Have you heard of being successful before? So what they wanted to know is, could they continue to get LTD benefits while going back to school to retrain? And I had said that what they're proposing makes a lot of sense, and it can be in the interest of the insurance company that try to go through the voc. I always tell people, try to go through the CPP Disability Voc Rehab program and be upfront with the LTD insured, what the plan is. But it's hard. Most insurers don't want to pay people that are capable of going back to school because they say, if you can go back to school, you should be able to do some type of work. It's this age-old problem. So it looks like Neo came back with more. I think they've answered. This almost seems like it's okay. Yeah. Okay. I won't go into all this. Neo's just giving more recommendations on how to approach the company and things like that. All right. Looks like we're up to date on questions in here. I've never been so up to date on answering LTD mediation and surveillance. Okay. Here's another one. What's this one say? Hi all. My LTD claim was denied. Mediation is scheduled. In the meantime, I am stressing out about being surveilled, although I am doing nothing wrong. I am living within the confines of my medical condition. Are PIs, private eyes, allowed to put GPS trackers on your vehicle? I haven't noticed anyone watching me or following me. I'm always worried of going to a friend's house. Yeah, I don't think they can track your vehicle without a warrant. An insurance company, yeah. They would never do that. That would be so bad if they got caught secretly putting trackers on people's vehicles. That would be very bad. Now, what they can do is if you wear one of these watches. Oh, I don't have my watch on. If you've got one of these Apple watches that have GPS, they could try to subpoena that data. These watches track you wherever you go, so they could try to subpoena your data. Now that's even hard for them to get. Yeah, look here. It would be an absolute PR nightmare for an insurance company if the news found a yes. They wouldn't do it. I don't think they would ever do it because it just would be such a legal nightmare. Yeah. I'm always worried that going to a friend's house for yeah, that is not going to derail your claim. I agree 100% with buckets here. Going to a friend's house is not going to derail a claim. They're not insurance companies are not going to put trackers on your car. There's no way. They can barely do like just ordinary surveillance, right? Like the way the laws are written, they have to have reasonable grounds to even do surveillance. They can't just say, "Oh, we're going to go put surveillance on this." They have to have a justification to do it. And then when they do surveillance, it has to be done at a proportional amount. Like they can't just say, "Oh, let's just put this guy under surveillance for a month." Like it has to be the minimum surveillance necessary for the situation because of how much of an invasion of privacy it is. So it's a real minefield, and I don't see insurance companies wanting to test the limits of it, honestly. All right, I'm going to leave it there. I'll be back tomorrow. The next 2 days are going to be pretty hectic, but as far as I know, I'm planning on doing shows tomorrow and Wednesday. I leave Friday for I'm going to be gone for the rest of the week, but it's going to be a busy couple of days. Hope to see you guys back here tomorrow. I wish you all the best. Take care.